Welcome to Just Asia, AHRC TV's weekly human rights program. These are the headlines. Indian judgment spotlight arbitrary nature of death penalty sentencing. New UN report released on Rohingya refugees. Mob wants to lynch Hindu businessman in Pakistan. Mob tries to lynch Dalit man in Nepal for worship on non-Dalit land. International concern growing at continued detention of rights activists. Government overlooks serious human rights issues during UPR. UN calls for release of Thai activists charged with lèse majesté. Welcome to AHRC TV's Just Asia. I'm Annie Lin. This week, Just Asia begins with the Indian Supreme Court upholding the death penalty awarded to 4 convicts in the 2012 Delhi gang rape and murder case on May 5th. Commonly known as the Nirbhaya case, the brutal attack of a 23-year-old woman shook the nation, causing widespread protests across the country. India awards the death penalty on the doctrine of rarest of the rare, and the Supreme Court held that this case fell into that category, shaking the collective conscience and thus warranting the death sentence. Another judgment was passed in the same week in the Bilkis Bano gang rape case, where the Bombay High Court upheld the conviction of 12 accused in a crucial move, set aside the earlier acquittal of 5 policemen and 2 government doctors. Bilkis Bano, then 19 years old and pregnant, was gang raped during the 2002 Gujarat riots, and 14 of her family members were murdered while they were trying to escape a mob. Bilkis Bano had to go through hoops to get her complaint registered and investigated, receiving threats and dealing with insensitive and apathetic authorities. The 2 cases spotlight the debate on the death penalty in India and the arbitrariness of the rarest of the rare doctrine, given that in both cases the women were brutally gang raped. Just Asia speaks to Urmila Pullat for more details.
Last week, 2 important judgments were passed in India. The first was a Supreme Court judgment in the December 2012 Nirbhaya gang rape and murder case, where a young 23-year-old physiotherapy intern was gang raped in a moving bus and murdered. The 4 rapists were earlier sentenced to death by the Delhi High Court, and this was upheld by the Supreme Court last week. The second case was the Bilkis Bano case, where a 19-year-old pregnant woman, Bilkis Bano, was gang raped in 2001-2, and 14 members of her family, including her daughter and mother, were killed by a murderous mob during the 2002 Godhra riots in Gujarat. In this case, the Bombay High Court upheld the life imprisonment and dismissed the Central Bureau of Investigation, the CBI's appeal for enhancement of the sentence. The Bombay High Court held that, on technical grounds, the accused, the convicts, were not history cheaters or hardcore criminals, and that they were part of a murderous mob moving in search of Muslims, and they were boiling for revenge. And although the bench agreed that the crime is uncommon, they said that the sentencing policy, however, was required to be balanced on the scale of proportionality. They also alluded to the delay of 15 years during which the convicts were in custody as a ground to not enhance the sentence. So these 2 cases have brought the debate back squarely onto the death penalty in India and the circumstances in which it is passed. Death penalty in India, the sentencing policy is based on the rarest of the rare doctrine and on the principle of collective conscience. The concept of rarest of the rare was explained in the Machi Singh case, which states that the collective conscience needs to be so shocked that it will expect the judges to inflict the death penalty irrespective of their personal opinions. But the fact is that the awarding of death penalty in most of the cases can come down to personal opinion, because there can be no one way to define the rarest of the rare case and what is the collective conscience in India and what can shake it. These 2 cases very clearly show that these are arbitrary notions which can be swayed by the public clamour and by media attention, which was the case in the Nirbhaya case. The case somehow really shook India. There were mass widespread protests led to the amendment of the criminal law, and also in this case the death penalty being awarded. Whereas in the Bilkis Bano case, there wasn't that much widespread media attention, and the kind of outrage that accompanied Nirbhaya was not seen in the equally horrific Bilkis Bano case. And so they show very clearly that these are discretionary notions. What is rarest of the rare and what shakes the collective conscience? And what is collective conscience in the first place in a country like India. And so these will be subject to the bench, to the judges that are hearing the case. And given the nature of our justice system is such that there have been many cases in which innocents have been held for, say, crimes of terrorism and have been acquitted after many years, it is clear that the death penalty needs to go and has to be abolished.
Next, a new report on forced displacement by the UN Refugee Agency has stated that more than 168,000 Rohingya have fled Burma in the last 5 years. The UNHCR's 2016 report on mixed movements in Southeast Asia, released last week, highlights the complex dynamics behind the continuing exodus from Burma's Rakhine state. Rohingya displacement made headlines last October when a security clearance operation drove an estimated 43,000 civilians into Bangladesh by year's end. By February 2017, the estimate stood at 74,000. The report offers a snapshot of 85 Rohingya women and girls in India, Indonesia and Malaysia. It found that the majority of them married young, between the ages of 16 and 17, and gave birth at an average age of 18. Those in India appeared to be more literate and educated, and were more likely to have chosen their own husbands. 1/3 of the 85 women and girls said they were victims of domestic violence. UNHCR has been working with host countries on the temporary stay and protection of Rohingya refugees, which includes granting them access to basic services and legal work. Pakistan witnessed another vigilante attack recently, with a mob gathering outside a Balochistan police station demanding that Hindu trader Prakash Kumar, who was arrested on blasphemy charges, be released so he could be lynched. When police refused, the mob opened gunfire and started beating police officers, resulting in the death of a 10-year-old boy. 3 police officers were injured, as were 1 other man and 1 child. This is the 3rd major vigilante attack on persons accused of blasphemy within 30 days. Earlier, journalism student Marshal Khan was brutally beaten to death at a university in KP province, followed by the attempted lynching of a mentally disabled man in Chitral. It is alleged that the incident was initiated by the traders and workers of political and nationalist parties in Hub, Lasbela district of Balochistan. The aim was to dislodge Hindu businessmen from the district who hold 40% of the area's business. A mob in Nepal, meanwhile, tried to chop off a Dalit's head for worshipping in a temple located on non-Dalit land. The Dalit man Rampakan Kori was celebrating his successful return from Qatar by visiting temples located around Baloha village on April 29th. While worshipping at the Sri Kadamai temple located on his non-Dalit neighbor's land, the landowner Sripati Kurmi and other non-Dalits abused and beat him. One villager tried to cut off his head to sacrifice before the goddess. As Rampakan's brother Jaganarayan tried to save him, his 3 fingers were chopped off. Rampakan's family registered an attempt to murder case the following day, but the deputy superintendent of police is threatening to jail them if they do not make a settlement. The landowner's family are threatening to kill them if they do not take back the registered case. Just Asia speaks to Jaganarayan for more information.
हमारा नाम जगनारायण खोरी हो। हम जिला कपिल वस्तु रहे वाला आदमी हुई। हमार पंचायत दोहनी हुए वार्ड नंबर 6। एक बाद में हमारा भाई विदेश से आ रहा पूजा कर कारणमाई के थान में सेवती चौधरी के ज़मीन में वो कारणमाई का थान रहा। वहाँ भा है कि काहे गए हमरे जौन है ज़मीन में चमारिक जात बिके तो काहे हमरे ज़मीन में गए। फिर बाद में हमार भाई वापस लौट के आए, हमारे भाई के मारे काटे दौड़े और हमारे भाई के नाम राम खोरी। अच्छा, फिर एक बाद में कुकुरी भुजाली लेके 10-15-20 मिला मिल के आए के और हमारे भाई के मारे जाते रहे। चमार के गाड़ी भी तमाम दीन एक बाद मरहू दौड़े, फिर हम गए बचावे खेती, बचावे गए हमार हाथ काट दी, हमार हाथ काट दी, काटे के बाद हम अब गाड़ी हुआ तमाम कुल भय, फिर चलाएँ हम घरे अपने। एक बाद में इन्हें मुद्दा छोड़ी तो पुलिस प्रशासन में नहीं डरता भय, हेल्प पोस्ट में डरता है। अब उल्टे वजह हमरे किए हैं, पुलिस हम में पकड़े आवत, मार काट तीन हमरे सिरे। अब हम तो बैठे हैं, उल्टे हम ही पुलिस पकड़े आवत, हमरे लिए तो रक्षा हो जाए, उन्हें पकड़ जाए कुल मिला, हमें न्याय मिले, वह हमारे लिए ठीक है। अब उल्टा हम के ऊपर केस न लगा। हाँ, ये सब झूठ हो, जो जान मारी केस रखे हैं सब टोटल झूठे हो।
There's international concern about the extended pre-trial detention of 5 Cambodian activists held for more than a year. The 5 staff of the Cambodian Human Rights Development Association are being held for allegedly bribing a woman to change testimony that was damaging to opposition leader Kem Sokha. A Cambodian court late last month agreed to allow a 6-month extension of the activists' pre-trial detention. The cases are seen as part of a campaign by Prime Minister Hun Sen's government to weaken its political opponents, especially ahead of nationwide local elections in June. Cambodia's veteran opposition leader Sam Rainsy is facing prison time for defamation and other charges he alleges are groundless and politically motivated. He has stayed in exile and resigned his position as head of the Cambodian National Rescue Party, which is now held by Kem Sokha. The US State Department issued a statement last week noting the delay in holding a trial and how it stressed the detainees' families. It urged Cambodia to meet its international human rights obligations. A similar statement was issued by the EU, calling for the rights of the detainees to be upheld. In Indonesia, several human rights groups, including the Asian Human Rights Commission, watched live the country's universal periodic review process last week, during which 113 countries questioned the government and made recommendations to strengthen human rights protection in the country. The Indonesian government delegation did not acknowledge certain human rights problems, such as repeated violence in Papua, including restrictions of press freedom. Even as numerous countries recommended that Indonesia abolish the death penalty, the government insisted that it is needed to eradicate and save the country from illegal drug offenses. Local groups conducted a public discussion on relevant issues during the review, noting that the government report does not comprehensively touch on unresolved human rights problems in the country. Mr. Asep Komarudin from the Press Legal Aid highlighted press freedom and freedom of opinion.
Kemarin itu terdapat beberapa rekomendasi untuk tidak mengkriminalisasi political expression, tetapi kemudian prakteknya hampir 20 kasus penangkapan yang memang penangkapan bersifat masif, hampir sekitar 1000-an warga yang sedang melakukan ekspresinya ini ditangkap dan kemudian beberapa diproses dengan dikenakan pasal makar, padahal mereka sedang melakukan ekspresi seperti perayaan ulang tahun dan sebagainya. Nah terus dan bukan juga cuma terjadi di Papua, tetapi kemudian terjadi juga di beberapa daerah yang lain. Terakhir misalnya ada terjadi di Jogja ketika mahasiswa sedang demo, kemudian mereka direpresif oleh aparat penegak hukum dan kemudian juga dikenakan dengan pasal makar. Selanjutnya adalah berkaitan dengan revisi penal code. Itu memang sudah dari 2012 kemarin untuk merevisi pasal-pasal yang berkaitan dengan kriminalisasi aktivis, human rights defender untuk segera direvisi. Nah, kalau prosesnya sekarang kita sebentar lagi akan disahkan KUHP ini, tetapi kita melihat justru malah isinya dari penal code ini malah tambah lebih buruk dibandingkan yang sebelumnya. Kalau misalnya beberapa pasal yang sudah di judicial review di Mahkamah Konstitusi seperti hak saya artikelen sudah dihapuskan, tetapi kemudian di draft yang terbaru ini dimasukkan kembali dan ini kemudian di parlemen sudah dipaskan, artinya sudah disetujui akan tetap.
The Thai military junta has been urged by the United Nations Human Rights Officer for Southeast Asia to immediately end the arbitrary detention of political activists and release 6 people detained for criticizing authorities. Activist Danai Tipsoya and human rights lawyer Prawit Prapanoko were arrested on April 29 for criticizing the Thai king on Facebook. None of the activists have been given access to legal representatives and their families. Since Thailand's 2014 military coup, the ruling junta has consistently used lèse majesté, sedition and cybercrime laws to crack down on activists. A March 2017 review by the UN Human Rights Committee raised concerns that a growing number of individuals had been arrested and detained at undisclosed places without access to lawyers, as happened with Pravit and Danai. Secretly detaining rights lawyers, critics of the monarchy and other dissidents has created a climate of fear in Thailand that is generating international outrage, said Human Rights Watch. Pravit could face over 150 years in prison for 10 charges under lèse majesté and 3 for sedition. That is all for this episode of Just Asia. For more on these and other issues, please visit www.humanrights.asia or www.alrc.asia/justasia. Thank you for watching and see you next week.